Thank you, Ari, and good afternoon and good morning to those on the West Coast. I'm Caroline Ostro, Judicial Nominations Campaign Manager here at the National Council of Jewish Women, and I'm thrilled to open this webinar and officially welcome you to today's discussion. Lead Organizing Skills for Grassroots Advocates is a monthly webinar series designed to provide organizing and advocacy skills. Today's webinar is the last in a very special three-part series of Lead, focusing on the intersection of abortion and other critical issues. We are incredibly grateful to Kate Ryan, Legislative Director at NARAL Pro-Choice America, who will speak to us today about abortion and the Supreme Court. For those of you new to NCJW, welcome. We are a grassroots organization of over 90,000 volunteers, advocates, and supporters who turn progressive ideals into action. Inspired by Jewish values, we strive for social justice by improving the quality of life for women, children, and families, and by safeguarding individual rights and freedoms. Since our founding in 1893, we've supported access to family planning and reproductive health. We were early advocates for safe and legal abortion rights and access, and we continue this important work today at the state, local, and national levels. NCJW is also a leader in the fight to ensure the federal bench reflects the communities it serves with fair, diverse, and independent judges who will safeguard equality and justice for all. Through Benchmark, our judicial nominations campaign, we build an educated electorate on the federal courts. As you'll learn or may already know, federal judges serve lifetime appointments and make decisions that impact every aspect of our lives, from voting rights to LGBTQ equality, to religious freedom and immigration protections. Over the years, reproductive rights have been advanced and rolled back in federal courts, impacting access to safe and legal abortion, insurance coverage for basic health care, when a person may choose to terminate a pregnancy, and beyond. Beginning with its 1973 decision in Roe v. Wade, the Supreme Court has shaped abortion policy and the standards at all federal levels used to evaluate restrictive laws. Is Roe still the law of the land? What's at stake as states continue to pass laws designed to overturn Roe? What can we do to advocate for a judiciary that will protect the constitutional right to abortion? Today, we have the pleasure of learning that from two issue experts. NCJW's very own legislative associate, Shannon Russell, will cover the evolution of the Supreme Court's abortion precedent. Shannon leads our federal advocacy efforts surrounding reproductive rights, health and justice, religious freedom and healthcare, and she meets with members of Congress and their staff and the administration officials to discuss pending legislation and regulations and creates written advocacy resources. Shannon received her law degree from George Mason University. Kate will then discuss pending cases that could chip away at current legal standards and why the courts and judicial nominations matter. As legislative director at NARAL, Kate leads their federal advocacy agenda by defending and improving women's access to the full range of reproductive health services and ensuring executive and judicial nominees are committed to upholding the constitutional right to choose abortion and advancing reproductive freedom. Previously, she was the senior program coordinator at the National Women's Health Network, where she led the Women's Healthcare Quality Improvement Program. She also worked on healthcare reform and women's issues for U.S. Representative Joe Sestak, and received her Master's of Public Administration from the NYU Wagner Graduate School of Public Service. Following Shannon's and Kate's presentations, we'll discuss how you can take action to protect our courts. We'll then move to a Q&A. So please use the chat box to submit your questions and we will get to them then. And without further ado, here is Shannon.
Hi, everyone. Thanks for the introduction, Caroline. I'm about to share my screen so you'll be able to see our PowerPoint today. Okay. So as Caroline said, I'm Shannon Russell. I'm NCJW's legislative associate and I use she, her pronouns. So today I'll be tracking the evolution of the Supreme Court's abortion precedent. So the period we're going to be talking about today spans 4 decades. And as you can imagine, the court changed considerably in that time. You can see a visual representation of that on your screen, how much the court changed. So it's not a surprise that their interpretation of abortion law also changed as well. So in order to understand this and get a clearer picture, we need to go over a few key constitutional law concepts to get started. So here's the 14th Amendment. The 14th Amendment includes critical constitutional protections like the Equal Protection Under the Law Clause and also the Due Process of Law Clause. So what does this mean exactly? So the court's interpretation of the Due Process Clause is divided into two camps. We talk about procedural due process, which just basically means that when the government acts in a way that deprives you of life, liberty, or property, as it says in the 14th Amendment, that the procedures that they use to do so must be fair. So like a fair hearing, notice, opportunity to be heard, all of that good stuff. So there's also substantive due process. And this happens when the law itself, not the procedures that are used to enforce the law, needs to be fair and reasonable. So under this doctrine, courts protect certain fundamental rights from government interference, even though these rights may not be specifically written in the Constitution. So an example of this would be, although there's no specific right to privacy written out in the Constitution, the court said in Griswold v. Connecticut that this right stems from other amendments, like the First Amendment's Freedom of Association Clause or the Protection Against Self-Incrimination. So the court determines if a right is fundamental by looking at whether it's deeply rooted in American history or tradition. And it's important whether a right is deemed fundamental or not, because this affects the test that the court applies if the government is working to interfere in that right. So say a state passes a law that interferes with the right to religious freedom, which the court and the legislature has deemed a fundamental right. Since it's a fundamental right, the court uses strict scrutiny, which is the most difficult test to pass. So the state has to have a compelling governmental interest to act, and the law has to be narrowly tailored and to achieve these very important goals that the law is trying to advance. So the state, as you can see from this chart, the state usually loses if they're trying to restrict this fundamental right. But if it's not a fundamental right, the court applies a rational basis test. And in that case, the law only has to be rationally related to a legitimate government interest. And in that case, the state usually wins. The court usually says, it's okay for you to restrict this non-fundamental right. So this may seem a little bit arbitrary, and that's because it is. So, con law lesson over. How exactly does this relate to abortion law? So in 1973, laws like the law that was challenged in Roe versus Wade, which made it a crime to get or attempt an abortion unless it was necessary to save the mother's life, governed in a majority of states. So the Supreme Court changed this by holding that only those laws that were narrowly designed to address what it determined to be the compelling state interest of protecting health, medical standards, and potential life justified constraining a woman's fundamental right to abortion. So they're using all of these key words: fundamental right, compelling state interest, narrowly drawn. This means that they're using that strict scrutiny standard that I just talked about. So they're affording the highest level of protection possible to the right to have an abortion. So the court allowed states to place increasing restrictions on abortion corresponding to gestational age. And this is what we refer to as the trimester framework. So in the first trimester, the court said that the decision to have an abortion is a private medical decision solely to be made between a woman and her doctor. So they didn't allow any governmental interference. After the first trimester, they allowed restrictions to safeguard maternal health, so long as these restrictions pass the strict scrutiny test that I was talking about. So as I said, this is the strongest level of protection afforded to the abortion right by the court. and it remained in place for the next 19 years. So as you can see, I've spelled it out here. So to restrict the fundamental right to abortion, the government must have a compelling interest, and the law must have been narrowly tailored to accomplish this interest via the least restrictive means available. Okay, then we get to Casey. So after Roe, you can imagine that states continued to enact abortion restrictions, like the Pennsylvania Abortion Control Act that was challenged in Planned Parenthood versus Casey. It included many provisions that we still see today, like a 24-hour waiting period and a parental consent requirement, but it also included these reporting requirements and a spousal notification requirement. So actually, Justice Blackmun's papers that were made available after his death showed that there was initially a majority of 5 votes to totally overturn Roe versus Wade and Casey. But Justices O'Connor, Souter, and Kennedy formed this middle ground block where they upheld Roe's essential holding while really gutting everything else. So they believed that Roe had gone too far and that it had and they wanted to give states more authority to regulate abortion. So they crafted this undue burden standard, which O'Connor had actually written about in other abortion opinions, but she had written it in concurring opinions. So it didn't really count before Planned Parenthood versus Casey. So here is the undue burden standard. And what I've highlighted is really the important part. A finding of an undue burden is shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. So under this test, the court upheld all the provisions of the Pennsylvania law except the spousal notification requirement due to concerns about domestic violence. But you'll notice that what's missing in this test is some of the buzzwords that I pointed out before, like fundamental right, or narrowly tailored, or compelling government interest. That's because they took away this strict scrutiny standard that they had previously applied. So Casey is actually more in effect than Roe. Many people talk about their fear of Roe being overturned, but a lot of parts of it already have. What people are really referring to is the fact that we want to safeguard this fundamental constitutional right to abortion that was reaffirmed in Casey. So unfortunately, not only was this undue burden standard that we just talked about much weaker than Roe's strict scrutiny, but the test itself was also very vague. What does an undue burden mean? If we think that the levels of scrutiny are arbitrary, the undue burden standard is even more vague than that. So it's no surprise, again, that courts struggled to apply the undue burden test in later abortion cases. So legal scholars often call the subsequent use of the undue burden standard inconsistent, confusing, and problematic. So nothing exemplifies this more than the contrasting decisions in Stenberg versus Carhart and in Gonzalez versus Carhart. Both cases dealt with measures restricting so-called partial birth abortion, which I want to say is not a medical term and simply refers to a method of abortion used after 20 weeks of gestation. So in Stenberg, the first case, a Nebraska doctor whose clinic performed second and third trimester abortions challenged a state law outlawing partial birth abortions. The court held that the law was an unconstitutional, undue burden on the right to abortion because it could have been interpreted to apply to all of these different methods of abortion, even though the legislature claimed that they were only trying to restrict one particular method. So importantly, the court held that the undue burden standard did not require the court to blindly defer to what the legislature said they were trying to do when they passed the law. Instead, they were to conduct their own analysis of the law's purpose and effects, which are two important words in the undue burden standard. So this seems a little bit more rigorous than that rational basis test that we were referring to earlier. They're giving more weight to the court's interpretation rather than the state and the legislature's interpretation of what the law is supposed to accomplish. However, in Gonzalez, the court pretty explicitly adopted the rational basis test. And you can see that in the quote that I pulled here. They use words like rational basis and legitimate interest. So this is a lower standard of scrutiny. To restrict the right to abortion, so they got rid of that word fundamental, the law must only be rationally related to a legitimate government interest. So this essentially made it easier for states to interfere with the right to abortion. In her dissent from the Gonzalez versus Carhart case, which she read from the bench, Justice Ginsburg wrote that the court had violated Casey and had upheld a law that surely would not survive under the close scrutiny that previously attended state-decreed limitations on a woman's right to reproductive choices, indicating that she too was confused by the court's back and forth between these standards of scrutiny. So states continue passing abortion laws and courts continue to apply the undue burden standard in an inconsistent manner. So in 2016, another landmark case reaches the Supreme Court, Whole Woman's Health versus Hellerstedt. So this case involved a Texas law that compels physicians to obtain admitting privileges at hospitals within 30 miles of their clinic, and also requires these clinics to meet the standards set for ambulatory surgical centers, which they don't need to because we all know that abortion is safe. In the majority opinion declaring these provisions of the law unconstitutional, the court briefly addressed the proper understanding and application of the undue burden standard. So this is what they said. They said that the rule announced in Casey requires that courts consider the burdens the law imposes on abortion access together with the benefits those laws confer. So they're saying that Casey established a balancing test and that the benefits must outweigh the burdens. And they also said that the lower court was wrong to equate the level of judicial review applicable to the abortion right with a less strict review applicable where economic legislation is at issue. So in the term less strict review, you should understand that the court was saying that rational basis review, that lowest standard of review, is not appropriate for abortion laws. They're saying that a higher standard applies to abortion restrictions, but they didn't return to Roe's strict scrutiny, and they didn't explicitly state that they were adopting a higher standard of review. But this is definitely heightened review. In her concurrence, Justice Ginsburg wrote that the law would not have even survived rational basis review, while in his dissent, Justice Thomas wrote that the court had overruled Casey and Gonzalez by adopting a more rigorous standard of review. So the court once again reaffirmed that it was not required to blindly defer or to accept a state's claims about its interests and how the law furthered those interests. So making it clear that the law must actually advance valid interests is, again, them rejecting this rational basis test in favor of something more in the middle. And so also the benefits must outweigh the burdens. So as the rest of the opinion demonstrated, courts must assess benefits and burdens using evidence-based findings. So to do this, the court examined medical evidence in the record, which included research findings concerning the safety of abortion and also the failure of admitting privileges and the ambulatory surgical center requirements to confer any health benefits. So in Whole Woman's Health, the court adopted a heightened scrutiny. So we're going from the strictest level of scrutiny, the most protection the court can afford, to possibly the lowest, to somewhere in the middle. That's where we are today. The undue burden standard is still in place, though arguably it's more powerful than it was when it was first adopted in Casey. So you can see all this in this amazing resource from the Chicago Kent School of Law. It's called the Body Politic Project, and I'll be sure to share that afterwards. And I'm now going to turn it over to Kate, who will discuss pending cases and what we might see in the future.
Hi, everybody. First, thanks, Shannon, for the great history of SCOTUS abortion case law. That was very impressively done summarization of gun law. And hi, everyone. I'm Kate Ryan. I'm the legislative director at NARAL Pro-Choice America. And so just to give a summary, in broad terms, I am going to go through the 2 reproductive rights cases that are currently pending before the Supreme Court. I'm going to do an overview of what's happening with judges across the federal courts, and then, as Caroline and Shannon mentioned, how we can take action against Trump stacking the courts with anti-choice judges. So there are 2 cases that are challenging state abortion restrictions with cert pending at the Supreme Court. So cert pending essentially means that one of the 2 parties in the lawsuit has appealed to the circuit court decision to the Supreme Court, and they're waiting to hear if the Supreme Court will take up the case. So the first is June Medical Services v. Gee. This case is challenging a Louisiana trap law that is identical to the one struck down by the Supreme Court in 2016 in Whole Women's Health. Essentially, I'm going to give the brief top lines of this case. I'll go into it a little bit more in a minute, but just for top lines, the district court struck down the law citing Whole Women's Health, Supreme Court precedent, perfectly appropriate. And the Fifth Circuit, however, reversed that decision. They refused to rehear the case with the full panel of the Fifth Circuit in obvious violation of Supreme Court precedent. So the Center for Reproductive Rights, the reproductive rights organization that is party to the lawsuit, they're bringing the suit, they appealed to the Supreme Court, and that is pending. So although the Supreme Court hasn't decided whether or not they're going to hear the case, it did grant an emergency stay of the Fifth Circuit decision until a final decision is made regarding the case. So the stay meaning that the law is not currently in effect in Louisiana while we're all waiting to see what happens. This stay is actually one of the reasons why the repro community is pretty confident that the Supreme Court will take up this case this term. The second case that's pending has gotten a little bit less news, but it's called Indiana versus Planned Parenthood of Indiana and Kentucky. The acronym is PPINK, my personal favorite Planned Parenthood affiliate acronym. And it is essentially challenging a law that requires a mandatory ultrasound 18 hours before you can get an abortion, and you have to get state-branded false anti-choice information at the same time. The district court enjoined the law, they blocked it, and the Seventh Circuit affirmed the lower court's decision, so everybody agreed this is a violation. However, the state of Indiana still appealed to the Supreme Court, and that is pending. Okay, so I'm going to start with the Indiana law, mostly because I'll dig more into June v. Gee, but I wanted to give some additional info about this other case that's pending. So let's see my papers. So before the Indiana law passed in 2016, patients in Indiana were required to have a mandatory ultrasound before receiving abortion care, but they could schedule and have it on the same day as their abortion, which most women did. As a result, this 18-hour delay between the mandatory ultrasound and the procedure, now patients would have to make 2 trips to a clinic to have an abortion. At the time the lawsuit began, PPINK had 23 health centers in Indiana. That number is already down to 17, and only 4 of their centers offer abortion services, one of which only offers medication abortion, which means that its services are time limited to the pregnancy. So now, instead of being able to go to one of 17 centers for the anti-choice information 18 hours before and then get your ultrasound the day of the procedure, patients will all have to go to one of these 4 centers for their fake information, their mandatory ultrasound, and then they have to go back to one of those same 4 centers for the actual procedure. You can imagine that these clinics are already really at capacity. So the idea that now their other partner clinics can't even provide the ultrasound or the information is really a problem. So it's unclear, however, whether or not Supreme Court will take up this case. All right. So June Medical Services v. Gee. I know that this picture paints a really stark sense of what is happening, But it is absolutely, without question, the goal of this Louisiana law. Their goal is to close clinics, just like that was the goal of Texas's law. And I don't think that we want to lose focus on what the actual intent of the law is. So in June Medical Services v. Gee, so this is the Center for Reproductive Rights case, they're challenging a Louisiana admitting privileges law that is virtually identical to the Texas law that's already been declared to be unconstitutional. The Louisiana law would prohibit physicians from performing abortion in Louisiana unless they have admitting privileges at a local hospital. While this may sound reasonable, that's why this is a trap law. It's not actually reasonable. For a number of reasons, admitting privileges are hard to obtain, but are also completely unnecessary, as abortion is one of the safest medical procedures. Doctors almost never need to refer patients to a hospital, which is part of the issue. A part of admitting privileges is easing, if you are constantly referring patients to a hospital, it eases your referral process. That's not needed for abortion providers. So that's kind of the summary of the law. And I will just direct folks to the Center for Reproductive Rights website if they would like full backgrounders on this law and how it interacts with whole women's health. So definitely utilize their great resources. So I want to also dig in on the impact of the Louisiana abortion restrictions. So access to abortion in Louisiana is already very, very limited. There, over the past decade, because of similar abortion restrictions, the state has gone from 11 clinics to 3 currently. And specifically, I want to dive in a little bit. There were 5 abortion clinics in Louisiana when the case was filed. However, by the time the district court struck down the law, because it was in effect in that period, they went from 5 clinics to 3, just in that period. And the district court found, when they ruled against the law, that only 1 clinic would remain open if the admitting privileges requirement goes into effect. So, and to look at the doctor side of it, there were 6 doctors who performed abortion in Louisiana when the case was filed. However, by the time the district court struck it down, they're already down to 5. And the district court found that only 1 physician would continue to provide abortion services if the law goes into effect. And this is in a state where approximately 10,000 people obtain abortion services every year. So the bottom line is that there will be 1 doctor left in a state to provide care for over 1 million women of reproductive age. That's just not tenable. So I want to get in a little bit to sort of what the next steps are in June v. Gee, just to have folks kind of aware of the advocacy opportunities. So there are 3 key dates that I want to flag for folks to keep an eye on and be able to engage. So the 2020 Supreme Court term begins in 2 weeks, begins in October. And it is likely, so in October, that's when the court starts to look at the cases that are pending before it and decide whether or not to take them up. So we believe it is likely that in October, the Supreme Court will take action on the cert petition, so the appeal request. And there are 3 possible ways this could go. So the first is they deny cert. So this essentially would let the terrible underlying Fifth Circuit decision stand. It means the law would go into effect immediately. There would be only 1 provider left in the state. And the truth is, it's believed that he would be unlikely to be able to continue to provide services for very long. And so the denial of the cert petition normally doesn't make news, but in this case, it will be really critical that we create a huge public outcry to what will functionally be a ban on abortion care across the state of Louisiana. It also effectively overturns the nationwide protections that were ensured in whole women's health. So that's basically the worst option. The potentially best option, but it's also pretty unlikely, is that the court would grant summary reversal. So essentially what this means is they would technically take up the case, but would not hear oral arguments. They would just announce that they're reversing the Fifth Circuit's decision, and the law would be struck down. So that would be amazing. And the Center for Reproductive Rights has asked for that, but we don't think that's very likely. What is the most likely scenario is that the Supreme Court grants cert and it proceeds through the normal oral argument process. So that typically means that cert is granted. We'll see oral arguments somewhere in the January to March framework. And then we would see a decision in June of 2020. So that's sort of the standard timeline. So there are next steps, and I'm certain you will hear from NCJW and from lots of other groups if that's the path this takes. So the key difference between when Whole Women's Health was heard and decided and now, when we expect June v. Gee to be taken up, is unfortunately Brett Kavanaugh, and I could not bring myself to put his face on a slide. So instead, it's a delightful picture, I think, related to Whole Women's Health. But Whole Women's Health, as Shannon said, was decided 5-3, with the late Justice Kennedy joining the majority with the typically considered progressive judges, Breyer, Ginsburg, Sotomayor, and Kagan. The dissent was Thomas, Alito, and Roberts. So with the understanding that I think we all share that Kavanaugh will happily vote to gut Roe, our only option is a scenario where Roberts actually demonstrates, which is sort of rumored, that he cares about the Supreme Court as an institution. He cares about the importance of SCOTUS precedent and what that means for the institution. Frankly, that he cares about his own legacy as a Chief Justice who cares about the Supreme Court's legacy. And thus, he doesn't feel like he can overturn a Supreme Court precedent in Whole Women's Health. I'll be honest, I am loath to hold my breath, counting on John Roberts to do the right thing for reproductive freedom. So we'll see. Stay tuned. Okay, so, and then hang on. So basically, this is a nice, but that's not really the right word, transition into why the courts are essential to protecting reproductive freedom. And to do that, I want to go back in time a little bit to provide a little context that I think is important to understand where we are today with SCOTUS and abortion rights. Because the anti-choice movement has always objected to Roe and has passed laws attempting to chip away or outright overturn it, it's essential to have an independent judiciary that supports constitutional precedent. But after Roe, conservatives tried and failed to ban abortion. And when that was unsuccessful in the 70s, they settled on a two-part strategy. One, chipping away at abortion rights through restrictions, and two, anti-choice judges. So if you'll click next, Shannon. So this one prong of this strategy is evident in the cases I just described. These are attempts to chip away at Roe. And I think it was best described in this quote. It's from an internal memo drafted by young conservative lawyers in the Reagan administration's Justice Department. And I like to use their own words because they're quite telling. "No one seriously believes that the court's about to overrule Roe v. Wade," they wrote. "Therefore, the key question is how to advance the goals of bringing about the eventual overruling of Roe v. Wade, and in the meantime, of mitigating its effects." The authors, and it's worth pointing out, this is a fun fact, though fun is maybe not the right word. One of the authors was a young, now Justice, Samuel Alito. So that's terrible. But they noted that there may be an opportunity to nudge the court. So presumably Justice Alito is really living his dream here. The other prong was publicly acknowledged by Pat Buchanan, who was the comms director for then President Reagan. So in this instance, they literally said, our conservative appointment strategy, appointment meaning appointment of judges, could do more to advance the social agenda, school prayer, anti-pornography, anti-busing, right to life, and quotas in employment than anything Congress can accomplish in 20 years. So in other words, the anti-abortion movement knew it had to focus on judicial nominees to achieve their long-term success. They had to change the balance of the Supreme Court. And the truth is, these anti-choice activists and politicians have been following this strategy to a T. Since the 80s, they have worked to restrict the right and access to abortion incrementally wherever possible, while simultaneously waiting for opportunities to pack the judiciary with judges who would vote to end Roe and criminalize abortion, which is their ultimate goal. And unfortunately, they have achieved that in Kavanaugh. So that is some interesting history. So I also want to talk about why judges nominated to the lower federal courts matter so much. And it essentially is about sort of the obvious piece of this is that they're basically the farm team for Supreme Court nominees a lot of the time. But also a vast majority of cases are decided by the lower courts. The vast majority do not ever get heard by the Supreme Court. And so because of the obstruction of Senate Majority Leader Mitch McConnell during President Obama's administration, Trump arrived in office with over 100 judicial vacancies, including a Supreme Court seat. That's where Gorsuch now sits. And that number has kept rising because people retire. And he is stacking the courts with primarily young white men, many of whom are hostile toward reproductive rights, civil rights, LGBTQ rights, and so much more. And arguably, this is the area of his presidency where he has had the most success. Feels like a terrible word, but I think that's definitely true, feels true for the conservatives who helped get him elected. So far, Trump has confirmed 150 federal judges, dozens of whom have demonstrated anti-choice records. So there are 2 Supreme Court nominees, Gorsuch and Kavanaugh. This graphic is old. It's an old Gallup assessment that says that there are 29 Trump Circuit Court judges. That actually is up to 43. And it is worth noting that Trump has had confirmed 43 Circuit Court judges in less than 3 years. That's almost as many as President Obama got in 8 years. Trump and Mitch McConnell are prioritizing this and they are rushing this through because they know that it will have effects that live beyond them. And he's also had confirmed 105 district court judges. So I think we're hitting the point at which 1 in 6 federal judges will be Trump nominees, which is pretty crazy for one president. Okay, so I do want to give a couple of examples of his lower court judges, just to give a flavor of how bad these folks are. And I should say, in addition to them being bad on fundamental constitutional rights, many of them are also deeply unqualified. The Republican Senate has confirmed to now be lifetime appointments on the federal judiciary, people who didn't get qualifieds from the Nonpartisan American Bar Association for reasons as various as, they graduated law school too recently, to they have never actually practiced the law, to ethics complaints around, they literally don't show up for work as a magistrate judge, so why should they be getting promoted? Things like that. It's pretty remarkable. But to dig into a couple of specific examples, one person who is now a federal judge is Wendy Vitter, wife of former Senator David Vitter, for those who recall David Vitter's fame. She is a judge for the Eastern District of Louisiana. And one of the more notable things in her record that stood out to us as we researched her was that she moderated a panel called Abortion Hurts Women's Health at Louisiana Right to Life's annual conference. And after one of the panelists referenced the anti-abortion resources available on her website, including a brochure about the 4 ways the pill kills, Vitter encouraged the audience to, quote, download it and at your next physical, walk into your pro-life doctor and say, have you thought about putting these facts or this brochure in your waiting room? End quote. It's worth pointing this out because the doctor whose brochure this is peddling not even your standard fake facts about breast cancer causing abortion, which has been debunked thoroughly, but one of the theories she was putting out there is that the pill kills women violently. And the story behind that is apparently that it somehow, taking the pill changes women's something. I don't think she knows anything about biochemistry, such that they're presumably more promiscuous, attract more dangerous men who will murder them. True story. That woman is a federal judge. Like, she asked people to take that into their doctor and put it in the waiting rooms. So she is now a federal judge. And another terrible example is Stephen Clark. He is now a judge for the Eastern District of Missouri. He represented a woman who wanted to use frozen embryos that were created with her ex-husband through in vitro. And while people may have different feelings about the underlying facts of the case, Clark, as an attorney, quickly crossed the line into strong anti-choice territory in the language that he used during the case. He actually suggested that the couples, they had children together, the couple's children would, quote, have to navigate the murky psychological waters of knowing they had similarly situated siblings who died at the hand of their father. He is talking about frozen embryos. These people are now federal judges. And there are many folks who might say, or senators who might say, what people do in their job, like lawyers have clients, you have to do what it's in your client's best interest. These are things that are above and beyond. No, Wendy Vitter was not anybody's client when she was suggesting that people take this fake information to their doctor. Clark is using clearly hostile anti-choice rhetoric. These are just above and beyond, and these people now have lifetime appointments to the federal judiciary. They're clearly biased and will not be able to be impartial. And we don't have a lot of hope that they will follow Supreme Court precedent, a lot like the Fifth Circuit in Louisiana's case just didn't. They just ignored whole women's health. And so, last slide. So I do want to note that there are some wins, and they are worth noting, so that I will end on a slightly more positive note. There are ones who have been so bad that they were withdrawn. So there are a few examples. This picture, the guy on the left is named Matthew Peterson. He is not a federal judge. And the one on the right is Senator Kennedy from Louisiana, actually. And his nomination was withdrawn because this Republican senator got fed up with Trump sending people who weren't qualified as attorneys over to the Senate to be confirmed as judges. Kennedy spent the hearing, hence you'll see his facial expression is quite clear, asking him basic legal questions like, have you ever argued a brief? Have you ever, what is a motion ad limine? Basic law school questions that he couldn't answer. And so was sort of Trump was shamed into withdrawing his nomination. There's another guy named Jeff Mateer who was withdrawn after video surfaced of him calling trans children part of Satan's plan. So clearly there were enough people who thankfully had, reasonable people who put pressure on the White House to withdraw that nomination. And my personal favorite story, I think, of a withdraw is a guy named Brett Talley, who had to be withdrawn because part of your process of becoming a judge is that you have to submit paperwork to the Judiciary Committee of the Senate. And one of the questions on there is around conflicts of interest or relationships with the White House. And he had said he didn't have any. I guess he forgot that his wife was Don McGahn's chief of staff, Don McGahn being Trump's lawyer. So he was also a ghost hunter, which is just a fun fact, an actual fun fact that I personally enjoy. But he was withdrawn because he essentially lied to the Judiciary Committee. So it is possible, but as you can see, most of these are process examples of not being qualified, with the exception of Jeff Mateer. They're still really important because these people should not be on the bench, and it's a starting place. But that's where things stand. So I'll turn it back over to Shannon and Caroline.
Thank you so much, Kate. That was so interesting. And Brett Talley is also one of my favorite for the ghost hunter reason.
Tuscaloosa Paranormal Society.
Right. I think Ari is going to let us know, or I can get it started. If people have questions, there is a chat function, and there's also a Q&A function in Zoom. So if you have questions for Shannon or Kate, or me, I suppose, feel free to put them in those boxes. And while we wait for you to submit your questions, again, via chat or via Q&A, we do have some that were submitted in advance. So Shannon, do you mind getting us started with those?
Sure. Thanks, Caroline. So we talked a lot about Supreme Court precedent, and one of the questions that was submitted via the registration was, how binding is Supreme Court precedent, and what does it take to overturn a ruling? So I can get us started in answering that. So the doctrine of stare decisis, of course, like most legal terms, it's Latin, and it means to stand by things decided. So essentially what that means is that the Supreme Court usually defers to its previous decisions, even if the justices that are now on the court might disagree with the justices who made the decision. Like, for instance, the middle ground judges that I talked about in Casey suggested that they didn't agree with the court in Roe and that they wouldn't have decided the case the same way, but they still upheld Roe's essential holding because they wanted to protect the authority and the legitimacy of the court and not appear to bow to political pressure, which is something that, like Kate said, we are hoping that John Roberts will do. But essentially, it takes a regular 5-vote majority to overturn precedent.
Yeah, the only thing I'll add is that there are considerations they take into place, things called reliance interests. And that means essentially, is this precedent, so that's why when you often hear like 40-year-old precedent, the reason they're referring to the length of time it has been precedent is that that precedent has often served as a legal basis for subsequent decisions. So when we talk about, Shannon talked about the right to privacy in Griswold and Eisenstadt in Roe, that has also, the right to privacy and those cases are also then kind of supporting frameworks for things like Obergefell. So there are other issues outside of repro where the right to privacy is really relevant and has been used. And so those types, if you undercut the reliance interests, you're then undercutting these other decisions that were in part based on that framework. Theoretically, it should be hard to do.
Yeah. So I can do another question that came in via the registration. So can you explain the path of a Supreme Court decision from when the judges decide to take a case to the ultimate final ruling? So like, what happens if the court decides not to take a case?
Yeah, so one of the scenarios actually left out for June v. Gee is that while there is a case, there's, as to Shannon's point, cert pending is a petition certiorari, and it's literally just Latin. So essentially, the court doesn't have to say yes or no to taking a case. It can just sit on their docket all term, and they can just leave it sitting there. That is possible. It's not super common. They often say yes or no that they will take the case or not take the case. But so essentially, if they take a case, you'll sometimes have what the Center for Rights asks for, like summary reversal or granting summary judgment. But often it's a briefing schedule where both parties file briefs, groups file amicus briefs in support of the various positions, oral arguments, and then a decision.
Yeah, and so it's important to note that, like Kate was talking about, petitions to hear cases, and that the court receives like 10,000 petitions each year, and that they accept less than 5, and they hear oral arguments in less than 1% of these cases. And that 4 justices must vote to accept a case. And if they don't, the decision of the lower court stands. Do you have anything to add, Caroline?
I don't have anything to add to that. I am reading the questions that came through in the Q&A.
Oh, what I will say though is, because I think this is a thing people may not realize, is that when, to Shannon's point, that 4 justices have to vote to take a case, we don't necessarily know who they are. They don't have to say who they are. So we don't know who voted to take or not take a case.
That was great. Thank you. I'm happy to read some of the questions again through the Q&A. Let's see. How realistic is it that some of the worst judges appointed will be removed or resign in time? Kate, feel free to answer.
Not very is the answer. Lifetime, I mean, like any job with a lifetime appointment, you're sitting in, unless there's a really good reason. It is pretty uncommon for a judge to be, this is kind of timely in the Kavanaugh notes, but just statistically it is uncommon for a judge to be impeached. But also for judges to resign. I mean, it generally has to be pretty bad. I think, I'm trying to remember his name, it's completely blanking on me. He is friends with Brett Kavanaugh, as a fun fact. A judge on the Ninth Circuit had to resign over sexual misconduct stuff, but it took, I don't know, people complaining over like a decade or something, and then eventually more and more stories coming forward in the era of Me Too, more recent, in the last couple of years, finally get this guy to resign. But unfortunately, it's not very common.
Kate, I would also just like to add to that by answering another question that came through in the Q&A, which is that given that so many anti-choice judges have already been confirmed, how can we talk about repro in court in a way that doesn't make people feel like we're doomed? In other words,
yes, I'm so sorry. No, I know my presentation is really depressing. But essentially you do have, despite, you know, I'm giving examples of Wendy Vitter and Stephen Clark and these really activist-y judges. And it is true that dozens of his 150 judges are demonstrated antis. They're essentially, what we're counting on is the institution of the federal judiciary, because lower courts, district courts and circuit courts, if they make decisions that fly in the face of the Supreme Court with any amount of regularity, like the entire system collapses. And so for the most part, as much as anti-choice judges who are district court judges, like Wendy Vitter might want to do something terrible, you still as a judge have to explain why you're making the decision you're making. And when you say, yes, I'm aware that it violates SCOTUS and I don't care, I'm doing it anyway, like you're really getting into some problem areas, because that won't stay confined to repro. And any judge can be a judge who does whatever they want. And that's actually a genuine problem, I think. And so there are a couple of outliers who will definitely do that. But for the most part, we've not seen, with Republican appointed judges overall, it's not, you know, the judges like to say, like, we're not Bush judges or Clinton judges or Obama judges or Reagan judges. Like, we're judges. We're here to follow the law. And so it's a little bit, this is a weird thing to say, but a little bit of a peer pressure element of, there are enough judges who care about the judiciary that they will frown upon and hopefully take action against colleagues who go totally rogue. And that's where maybe, I don't know if we'd see anybody resign, but you could definitely see somebody getting into trouble. It might be privately, but as long as they're keeping their own in line, that's where kind of a lot of our hope lies.
Thank you. Let's see. This question, I think, is for Shannon and Kate, really. What can we as NCJW advocates do to maintain Roe?
I can start unless you want to, Shannon. But I think, well, for one thing, there's a general sense in the press, in the public perception, and very much in the perception of senators, that Republicans care more about the judiciary and judges than Democrats do. And sorry, we're near LC4, so I can say that. But in general, there is a sense that progressives care less about the courts. And in part, that's because conservatives have spent decades of time and money making sure that their members call their senators not once, like, oh, support Wendy Vitter. The same person calls the Louisiana senator's office every single day until Wendy Vitter is confirmed. There is a certain amount of pressure that is put on Republican senators to confirm judges that Democratic senators say they don't get the same number of calls in support or opposition to judges that their Republican counterparts do. And so part of this probably is demonstrating to senators and kind of by extension, the press and the public, that progressives do care about the courts. And they are willing to really advocate on it. And unfortunately, it is a constant and ongoing process because the Senate's confirming several judges a week. So it's really calling all the time. It's a lot.
Yeah, thanks, Kate. And I would also say there's a federal bill that we support. It's called the Women's Health Protection Act. And it would actually create a federal statutory right to provide abortion and to get abortion free from all these restrictions that we're seeing in the states. And so that would definitely help to not have all these ridiculous things that are passed solely because they're meant to challenge Roe. It would take some of those away.
It would, and actually, yeah, I'm glad you said the Women's Health Protection Act. It made clear that most of these restrictions, mandatory ultrasounds, the medication abortion restrictions, the trap laws, the delays, all of those would be, because it would be creating essentially a right to abortion that is statutory and not just Roe. It would protect, frankly, the right to abortion even if Roe fell, but it would also stop all of these terrible bans and restrictions we're seeing in the states. And so the bill has 210 co-sponsors, which is amazing. And it's certainly something that is really a top priority to not just having a lot of co-sponsors, but, while we understand it doesn't have a chance in the Senate right now, we would love to see this bill move in the House.
Yeah, there's an action alert and talking points on our website about this bill. And the bill also has this provision in it that talks about the test that courts are to apply if a law is restricting abortion in violation of the act. And that is so important because, as I outlined in my presentation, the undue burden standard has been applied inconsistently, and we don't really know what it means. So that would be so important.
Yeah.
Thank you both so much. It's about time to wrap up. I'm going to address a couple of things that came through in the Q&A. One question was whether the undue burden standard applies only to people carrying unviable fetuses, or it's been established that it applies to all pregnant people. Shannon, correct me if I'm wrong. I believe it's all pregnant people, the undue burden standard. Okay, that answers that question. Thank you. And then another question came through about signing up for a listserv that sends regular ongoing updates about legislation impacting abortion rights and reproductive rights. I urge you to sign up for NCJW's action alerts. Shannon sends amazing updates and explains how to take action. So unfortunately, we don't have time for any more questions, so I'm going to wrap us up. But if you have any others, questions after this, you're welcome to email them to Shannon Russell, SRUSSELL@ncjw.org. Or if you have any questions about the webinar itself, please contact Ari Solomon at asolomon@ncjw.org. But I want to thank all of you for joining today's webinar and for your thoughtful questions. This has been such a great way to wrap up our special abortion and webinar series. And I especially want to express our gratitude to Kate and NARAL Pro-Choice America for her help in planning and making this webinar happen. We really value your partnership, and we're so proud to work all alongside you in the fight for abortion.
Couldn't agree more.
And for federal courts. And I also want to thank Shannon Russell on behalf of myself and the rest of the staff at NCJW for sharing her expertise with us today and every day, and Ari for leading this fantastic webinar series. So after having learned so much about abortion, the courts, and judicial nominations, I urge you to get involved and use this information in your advocacy work. An easy and important way to start is by contacting your senators today and urging them to impose a pending nomination. Stephen Menashe has been nominated to serve on the U.S. Court of Appeals for the Second Circuit, and he's an individual that's demonstrated complete and utter disdain for women and the LGBTQ community. He's even advocated for something he calls ethnic homogeneity, which echoes these white nationalist calls for racial purity. So if you search Menashe, M-E-N-A-S-H-I, on NCJW's website, you'll find an action alert and a lot more information. Please keep an eye out for an email from us with helpful links to our federal courts and reproductive health rights and justice resources, in addition to an amazing resource from NARAL called Trump's Antichoice Judicial Nominees. It's a resource that I use in my work all the time, actually, and I think you'll find it really helpful. And please reach out to us if we can assist you in this vital work. You'll also receive a recording of this webinar and a short evaluation. Please do fill it out. Your feedback informs future programming, so we appreciate your feedback. And as already mentioned at the beginning, we will not have an October lead because of the Jewish holidays and office closures. And so our next webinar will be on November 20th at 1:30 Eastern, and we'll focus on building our teams to be effective advocates. So thank you all again. A huge thanks to Kate, NARAL, Shannon, and have a great day.